Hello, everybody. Welcome to the ACMA webinar on the California Consumer Privacy Act. I see that we still have a few folks filing in. We'll be beginning in just one moment. Hello, everybody. Good afternoon. I'm Hamilton Davison of ACMA. You are at the California Consumer Privacy Act webinar. We do have folks still filing in, but I think in respect to the time of those of you that have shown up, we'll go ahead and start. We have a great program. We're going to give you quite a bit of chance to ask questions. You're welcome to ask questions at any time. We also have a Q&A at the end of the session that you're welcome to participate in. There is a Q&A box on your screen to put those in. I'll show that to you in just a minute. I'd first like to start by thanking our sponsors. You're attending this webinar free of charge because of the generosity of our sponsors, and for that matter, our supplier members at ACMA do a great job in providing support, not only financial support, but subject matter support and all other types of technical and contributory support. I would ask you all, whether you're an ACMA member or not, to please support our supplier members. It's really important to us, and I expect also to them. Few housekeeping items. I want to get in the, here's the agenda. Let's look at that in a moment. And I also have a poll to start in just a minute, ask you a couple of questions. But first, for those of you that are not as familiar with the Zoom system, the Zoom system allows you to ask questions. If you look down here at the bottom of the screen, you'll see this Q&A box. If you open that up, you will be able to type your questions right into the system, and I'll see them come up, and I will pause periodically to throw those out to our panelists. And then I believe the chat function is disabled on your end. There is also audio settings down here. If you're having trouble hearing or want to switch how you're listening to us, you can do that. And then up towards the right, you should have view options, which allows you to put the speakers on your screen as well as the presentation material. So we do have a ACMA privacy committee. If this is a subject that is near and dear to your heart and you'd like to help guide the ACMA privacy policy, I'd invite you to join our privacy committee. We're just forming that now. I'd also invite you to join us in September. Unfortunately, this year, given the pandemic, ACMA's national forum has not been able to take place live, and instead will be virtual. It's being held on successive Wednesdays, given that we all get a little overwhelmed with Zoom. It's being handled for a 2-hour slot each Wednesday on the 9th of September, the 16th of September, the 23rd of September, and then on the 30th of September, we're going to do a virtual lobbying day, which actually seems to work pretty well from the groups that have done it. And that will be all day long, but we'll be rotating folks in and out when it's time to meet with their respective member offices. So if you would pencil in the Wednesday, each successive Wednesday, starting at 3 o'clock Eastern on the 9th, the 16th, the 23rd, and if you'll reserve the 30th, we'll get some organization around that lobbying day and give you specific times to dial in. As you may have heard me say, it's a numbers game in Washington, and numbers count, and sophisticated industries and sophisticated companies participate in what's happening in Washington. This is also a good example of, it's not just a national game. This is a state game here, or I should say the CCPA started in California, as did Proposition 65. And it's pretty clear that state actions can have an impact even if you're not resident in that state. So not only is it a numbers game in terms of being connected to Congress, but it allows us, if we have a lot of members in a lot of states, to have a widespread intelligence gathering network, because you'll see things developing in your state maybe before we do, and can key us into what's happening so that we can take action. We're quite happy to help you build a relationship with members of Congress, and we have materials on that we'd be happy to share with both member and non-member companies. Today's panelists, we're going to hear from a subject matter expert, an attorney who practices in the privacy field, David Berland. We're going to hear from a service provider that does quite a bit of data manipulation and obviously handles a lot of personally identifiable information on behalf of their clients, Tom Berger. And we're also going to hear from a brand and merchant from the CEO of Vermont Country Store, Jim Hall. So we'll have their perspectives, their take on this, as well as getting your questions and getting your input. So I think with that, David, I'd like to turn it over to you.
Thanks, Hamilton. I appreciate the invitation, and I appreciate so many folks coming out today to virtually attend this exciting and address this exciting issue. I will say I'm a partner at Brandon Isaacson. Our offices are in Maine, but I'm a native Californian and a member of the California Bar. I hope you won't hold either of those things against me, but it does mean that this is an issue that's close to me in a couple of different ways. Very cleverly, you've given the lawyer the shortest amount of time to speak. Always a good idea, but I will try to briefly run through what the CCPA covers and what its dimensions are, so that what Tom and Jim have to say, the real meat of the presentation, will have some good context. First off, the threshold for compliance. Again, as Hamilton said, California likes to stretch the boundaries of its jurisdiction, and so they're looking to regulate companies who have in excess of $25 million in general revenue without regard to where that revenue comes from. It's not limited to California. Or alternatively, companies that buy, sell, or use personal information of in excess of 50,000 California residents. So that brings in a broad range of businesses from a broad range of industries, perhaps even broader than the drafters of the statute imagined, but that's why we're here. It provides protection for California consumers. All that means is human people who live in California, as opposed to businesses. But a consumer does not have to be someone who is in a business relationship with you. If you come to possess some of their personal information, then you have a sufficient relationship that implicates the CCPA. And what's personal information? There are some technical categories that are mentioned in the statute, but very broadly speaking, and this language comes from the statute, it's information that identifies, relates to, describes, or is capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. So you can see the breadth of information that's potentially implicated. That's sort of the scary side of things. There are some mitigating factors that will help you manage this. I like to think of the CCPA as both a worst and a best case scenario, in a sense. What you end up being required to do isn't quite as draconian as it might appear at first. So if you could switch over to the next slide, Hamilton.
David, if I may just jump in, we both have a question, and I forgot to initiate the poll. So I'd like to do the poll while I ask the question. I'd like our participants to respond to the poll. And the question is, what is the legal and technical definition of selling data? Does placing, say, a Google Analytics site usage cookie count as selling?
The answer to that question is now coming into focus, and it's not necessarily the answer we would like to know. Sale means, under the statutory definition, an exchange of personal information for any form of consideration, whether that's monetary or non-monetary. And the Attorney General, in the regulations that he has just submitted for approval through the California regulatory process, has asserted that he will be taking the position that a do not sell request will implicate third-party cookies and that type of technology. which definitely will create some headaches for folks trying to match up their compliance obligations with the technical limitations on their sites.
Okay, thank you. I see we've got a few more people that are still voting. I'll give it about 15 seconds more for you to indicate how knowledgeable you are about CCPA and how prepared your company is for CCPA compliance. That'll help our presenters understand where to pitch some of their comments. So
Yeah,
last call on the poll. Go ahead, David.
No, I was just going to say, and I can move on to discuss the broader categories of information, and it'll pop up in the slides. But essentially, you have a set of obligations under the CCPA that begin with a notice requirement. The timing of this is important, and the Attorney General and the regulations has made that clear. Notice is supposed to be required at or before the time that you collect the personal information. And that applied, as I mentioned, that potentially applies to cookies and other sort of technological-based gathering of information. What that means on a website is that you need to have a privacy policy featured in a relatively prominent place on your homepage and every other page of your website. That may also mean for catalog merchants, like a lot of the folks here, that you either should strongly consider or may have an obligation to provide some kind of offline notice. That's not a statutory requirement, but it is one that has been put into the regulations by the Attorney General. If where you meet your customers is at a retail location or in a catalog, and from that point you're collecting personal information, notice is required at that moment. The good news on that front is that the notice can simply be some form of directive to your online privacy policy. It doesn't have to be, you don't have to copy that out in print, but you do have to indicate to your customer how they can get to that relatively simply.
Okay,
yeah, go ahead.
Excuse me, David. I'm going to go ahead and close the poll, and people can see the results. As soon as I can get it up on the screen, bear with me. There we go. All right, that's what you've told us. Looks like we're mostly informed. Some of us are fully informed, some not quite informed at all. We're about split and fully ready to comply and almost ready to comply. And some of us are just starting and or have not started to comply at this point. When you're done with that, you can hit the close button. Your poll results will go away. And David, sorry for the interruption.
No, that's fine, and that allows me to streamline a bit because I don't want to be telling people information they already know. So most of you are very familiar with the notice. What you're providing notice of is that your California consumers have a right to request to know what information you have about them that's personal, and to have that information deleted, subject to a number of caveats. The first of which is that any request must be verified before you honor it. And the verification process can either take, if you have an online relationship with a customer that involves a login information, that's one way to verify. If you don't, then you need to use some forms of personal information, but not too personal, not a social security number, not financial information, but a zip code or an address or a telephone number or an email address, to make sure that you're speaking with a person who's asking about their information. Secondarily, when it comes to the deletion requirement, if you have a business reason to keep information, for example, in the merchant context, if you have obligations to report recall of the product that may kick in down the road, then you're not required to delete name, address, and contact information if you can truthfully respond to the consumer that we need to maintain this as a part of our business relationship with you. Then finally, we have the do not sell request. That applies to any business that's involved in the quote unquote sale of personal information, using the definition that I mentioned in response to the question earlier. And that requires you to have a separate mechanism with a what amounts to a do not sell link or button on your homepage that immediately takes someone to a web form that they can complete to opt out of the further sale of their information.
And we have a question related to the last slide, which is the $25 million threshold. Is that for the state of California only, or is that aggregated e-commerce revenues across the country?
No, and that is the revenue of the company, regardless of the jurisdiction that it comes from. I do anticipate that there will be some bold soul who will litigate California's ability to draw that, to reach out of its own borders to companies that primarily derive their income from other states or other jurisdictions. But on its face, it applies to the entire gross revenue of the company, regardless of where it comes from.
And how about if you're a subsidiary of a larger entity? How do you calculate that?
There is, I don't have it at my fingertips, but there is a definition of the term business that applies in that situation. And in essence, roughly speaking, if your business functions as a single entity, then you are treated as a single entity. If there's broader integration between multiple divisions or multiple subsidiaries, then you have to look at it. You have to get into the technicalities of the statutory definition to know for sure which side of the line you're on.
Okay, and I'm going to keep going if I may.
Yeah, please.
David, under the do not sell request, how does that impact the catalog cooperative databases? Maybe we want to wait and let Tom get into this, or Tom, you can jump in now if you prefer. If a company has a relationship, if a person has a relationship with a company A and they participate in that co-op, how does that affect that consumer's name in the database going forward, in the co-op database?
Yeah, I'm happy to address that in the first instance. The co-ops, to my knowledge, all of the ones that I'm aware of have taken the position that that is a sale of information, and that that they are subject, that transfer of information is subject to the do not sell requirements. And if Tom has anything to add in the moment, that's fine. Otherwise, we can circle back to it.
I agree with that. I'll talk about it a little bit more later, but I agree.
Okay, thank you, Tom.
And then if there are no other questions, then we just turn quickly to my last slide before handing over the reins to Tom. And
there are a couple more, some of them I'm going to defer, but this one is still relevant to this topic. Must you inform the consumer of the reasons you're keeping the information, or is it appropriate to process the request to the extent possible?
I guess the answer, if I'm understanding the question correctly, the answer is both. To the extent that you are able to respond to a request, say it's a request to delete, if there's certain information that you are able to delete because there's no underlying business purpose, then your response will indicate that you've deleted that information. To the extent you deny the request based on one of the statutory conditions, that ongoing business relationship or contractual obligation, or to comply with another set of laws, then you are obligated to inform the consumer of the categorical reason why you're denying the request, as to, say, name and address.
Okay, thank you. Next slide, David.
Yeah, that would be great. And I'll just try to do this real quick. And there's a number of questions that have come up relating to service providers and the difference between a service provider and a business. In essence, a business who has a one-to-one, or has a direct relationship, a first-party relationship with a consumer, that then transfers personal information of that consumer to a third party, say a printer or a fulfillment house or something like that. If that third party only uses your business's personal information under the terms of your contract for the purposes set out in your contract, that business is a service provider, and you have an obligation to pass on requests that you receive to them, and they have an obligation to honor them. And they are under those circumstances, subject to the same kinds of penalty risk as the business with the first party relationship. Critically, in the new regulations that are almost certain to go into effect at some point in the next month or so, a single company can be a business as to a certain set of personal information and a service provider as to a different set of personal information. And it's important to understand whether something that you do might fall into one or both of those categories, because it affects the obligations that you have. And it also affects the agreements that you might have with service providers. And there's been a lot of activity around amending agreements on both sides of that line to make sure that folks are aware of and in a position to comply with their obligations under the CCPA.
Right. Is anything else, David, that you want to add right now, or shall we move on?
No, I think I'd rather reserve any time that I'm sure I'm over time, but I'll reserve that for the Q&A.
Okay, very good.
The real interest.
Super. Thank you very, very much. And I do have some questions that you may want to weigh in on, but we'll save those for the moment and turn it over to Tom.
Okay, thank you. And we can advance the slide. Okay, so I'm Tom Berger. I'm CEO of Cross Country Computer. We're a data management service bureau. In addition to being a CEO, I'm also very involved in our security certifications and our compliance, which is what loops me into CCPA. I'll begin by describing, I'm not going to go in order of the slide here, but some of our services, just to give you context to the best practices that we're going to be describing, so you understand what services each applies to. So starting with, I think the most common one is merge purge, and real briefly, that's the data processing and support of preparing mail files that get delivered to your printer to ultimately deliver catalogs to your customers and prospects. Secondly is the matchback process is the most common name it's referred to. And importantly, that's the process of taking what could be considered an archived, and that's important, mail file, and use it in a current analysis to be able to analyze whether or not a recent customer might have received a direct mail offer that contributed to them making a current purchase. It's important for our clients to do matchback to understand ROI of their direct mail campaigns. Third would be list rental fulfillment was much more common maybe a decade ago. Today, due to the growth and reliance on the co-ops, which I'll talk more about in a second, there are not as many marketers that are directly renting their data renting/selling their data to other marketers via a service bureau, but I'll still touch on that briefly as we go. And finally, it's database services. We provide a variety of database services from simple to complex. I'll give you an example of each. On the simple side, we might be building an aggregate level database that really serves little purpose aside from allowing our clients to do house file selections into their direct mail campaigns, into their merge purges. Interestingly, some clients don't even really look at it as if we have a database for them in some of those circumstances, because they just look at us as a merge vendor. So it kind of speaks to the point of understanding the range of services your service bureau provides, so you know how to engage them in your compliance. And on a more complex side, it runs the gamut. More complex databases, multi-sourced, relational. We can tell you who bought the red fuzzy sweater on a Tuesday using a particular coupon code for $88. So in that vein, there's a whole bunch of data that we maintain on your customers. So for those clients that engage with us for those services, they're very aware of the CCPA implications. Some other services are a little bit more tangential, so I'm not going to go into a lot of detail during the meat of the presentation on those, and we can advance. Okay, so what data do we handle? It runs the gamut. The core that makes the world go round is name and postal address, but certainly we also maintain transactional detail on our clients' customers' purchases, email address, phone number, prior mail files. There's a lot of information we maintain, and I spoke to a degree about the services we're providing. Anecdotally, to give you a sense of scale, Cross Country has a few hundred clients, and interestingly, we've only received CCPA requests to date from a little north of a dozen or so, which is surprising to us. Maybe a little bit more at this time. We've circulated some communications to most clients with best practices and how to communicate with us. And that kind of brings us into the question of, if we're receiving so few, does it mean maybe your service bureau doesn't need to be brought into the process? And as David indicated, we are a service provider, and it is important from our perspective that we as a service bureau, given those services that I described, are definitely part of your CCPA compliance initiative. Given that, it becomes really important to understand, how do you deliver those requests to your service bureau? And the key really is consistency. In the beginning, and still kind of today, it's a little bit Wild West in the sense that a client will get a request, they're going to panic a little bit maybe. They are just going to hit forward on an email, sending us an unencrypted, unsecured email with PII. There's maybe nothing more than an email address from the California resident, which is okay, but ideally we'd prefer, where possible, that you try to look in your own system to find more information to pass to us, to give us more breadcrumbs as a service bureau, particularly postal address where possible. They're also often providing it today without instruction on what to do with it. So when we circulate our procedures, quote unquote best practices to our clients, we're trying to educate them on how to consistently deliver this information. First, from our perspective, we strongly request that it be sent via SFTP, secure SFTP. That's where, at least in our case, our clients are already sending us their different transactions to update, mail files, rented lists, and so forth, is already generally being passed to us via SFTP. So we encourage that. That's how CCPA requests should be sent as well. It's a small incremental lift to most of our clients to do that, since that's how they're already engaging with us as a service bureau. Next, from the standpoint of consistency, is going to be naming conventions and instructions. It's really important that we understand, that your service bureau understands, is this a do not sell / do not rent request? Is it a delete? Is it a right to know? As most of you, based on a poll, I'm sure are well aware, it is not uncommon to have many great customers of yours that love engaging with your brand, that are multi-buyers, want to receive the catalogs, want to maintain an account. They just don't want you to rent or sell their information to third parties. So when you just forward to a vendor, service bureau in our case, apply this CCPA without context to how, you run the risk of having them delete that from your database and from all future mail files, such that you would be over suppressing your very best customers. So consistency and labeling of those files and instructions when you tell your account executive, or whatever that title might be, how to apply them is really important. And finally, consistency on timing, and we can advance the slide and we'll touch there next. Okay, so some of this is repetitive, and certainly a lot of you know this, but I'll kind of give it to you from the perspective of your service bureau. Do not sell. Again, I always say, rent, but that's typically how people in our industry look at what they often do with their data. They're renting it to third parties as opposed to selling it. You have 15 days from when you get a verified receipt. Verified, David kind of touched on it. You have some reasonable right to be able to verify the person making your request has a right to do so. So Tom Berger can't just send you an email and say, delete all information on Miley Cyrus and Mickey Mouse, right? You have a reasonable ability to verify, and you have 15 days. So for those today, smaller number in our experience of marketers that are using a service bureau and maybe a traditional list manager to rent your data to third parties, then co-ops aside, and I'll get to that in a second, then you really should be sending those to your service bureau weekly, because often your database update schedule in the list rental world might be once per month as a typical. Now in our case, since we have a bunch of clients that are not engaged with us at all for the purpose of selling or renting, We do not discourage them from sending us these requests. We still would like them. We will still aggregate them. We'll maintain those, and we'll have them should there be an application that we need to provide, need to apply a do not sell type request. The co-ops are a wild card. For some clients, we will forward certain requests to the co-ops, but the thing to remember in the case of the co-ops is that if you participate in a co-op, so the assumption there, if you're not sure, is if you are taking data from a co-op for your mailings, then you are contributing to that co-op. Those co-ops, they are renting and selling your data every day, multiple times a day. There's nothing wrong with that. It's not illegal. It's very normal in the course of our industry, but it means that the cadence for when you might need to send requests to a co-op might be a lot more frequent than you have to send them to many of your other service bureaus. So that's just something to consider. Delete my info requests. That is something you have 45 days. So here too, you have to consider the cadence, the frequency that you're doing mailings or updating with your service bureau. You know, a typical schedule might still be once a month. If that is the case, it's real easy, right? Because you're already posting your transaction files and other files, suppression files and so forth, to your service provider once per month for that update, as the best example. You would just provide those CCPA requests at that same time through the same channel. That consistency is also important because it helps all of us there. It's a lot more difficult to track from an audit perspective and to ensure it's being done if you're kind of just willy-nilly, you know, sending emails to an account executive saying, apply this, do that. So the consistency is important. If you are updating more frequently, which certainly we have clients that are, or mailing more frequently, you're going to want to send those requests more frequently as well. If you're doing it less frequently, then you should talk to your service provider. I can, in a Q&A, I don't want to take too much time now. I can talk more about that if a question's asked, but talk to your service provider about if you're doing it less frequently, what's the right, you know, cadence and process there. Okay, next slide. Handling right to know. So these are less frequent. We've received a handful of these at this point. There's a couple of really fundamental things you need to consider from a service bureau's perspective in your response to a right to know request. First, and I would really suggest this for the other requests as well, that it's first good to check your own internal system, because for the prior point, the more breadcrumbs you can give to a service provider to find the data in our systems, the better. But it's particularly important in a right to know request. And the reason is that you have to consider your service bureau's consolidation logic. And consolidation, what I mean is, how do you bring together different orders or different customers potentially under one account? Service bureaus, kind of by definition, they have to use different match codes or weights and penalties or pinning system or something that has some degree of overkill or underkill in aggregating data together, combining records together. Now, really a great example of that is actually individual or household, right? There are some clients that by design, they explicitly want to look at a customer as a household. So in my case, Tom Berger and Elisa Berger were spouses, same surname, same address. Many of our clients would consider that one account. The important consideration there is under the CCPA, and by the way, when I speak of it, I'm talking from the red line version, which is not yet passed. We believe it probably will be, but in any case, it provides some good clarification on areas that might have been a little bit ambiguous previously. So the reg is basically saying that just because Tom Berger makes a request of you to know his information does not give him or you the right to automatically reveal information on Elisa Berger or somebody else. So it's good to ask your service bureau to give you the information they have on the person making a request, but you really need to do your due diligence in looking at what they're giving you to decide what is or is not appropriate to return. And where possible, we would again guide you to return data from your own source system as originally captured, as a best practice. And of course, consider if your service bureau has additional data points, then evaluate which of those you might want to additionally return. Okay, we can go to the next slide. Okay, so let's talk a little bit about, let's cut right to it. Where would we, cross-country, and where would your service bureau typically be looking to apply these requests when you send them to us? So first and foremost, it's going to be active databases. So that one seems to be a no-brainer, right? We're maintaining a database for you. It's got PII and your California consumers. You send us the request. We are going to go into your active databases, whether a marketing database, a list rental database, and we are going to, I'm mostly talking from a delete perspective here. We're going to go in there and we're going to delete that information. We're also going to delete that from any current mail files. Maybe there's a case, David can maybe comment on this further, if there's any ambiguity as to whether or not you have a right to mail to somebody if you get their name through another source, even after you've deleted them. However, from our perspective, we kind of take the don't poke the bear perspective. If somebody is going through the effort of telling you, take me off the list, don't sell, delete, then it's best to make sure that we try to suppress that individual from future mailings. So we're going to be putting them onto permanent do not mail files. I saw a question, I think, from Ben earlier, so we'll get to that in a second as well. List rental files, that kind of goes hand in hand with the database. We would delete from there. Matchback analysis. Earlier, I had mentioned to you that it's easy to look at your mail files as archived files, and we'll get to that next slide in a second as to what we don't have to delete. But it's important to understand at such point that you're pulling a prior mail file into an active analysis, then you then at that point have obligations to make sure that that delete has been applied. So that's a really important one to talk to your service bureau about as well. And I mean, broadly speaking, I also mentioned reuse up there. Similarly, if you take a reuse is pulling from a prior mailing, names, all the names or segments of names to include in a current or future mailing. There too, the archive file, once you're going into it to pull those names to a current mailing, you need to make sure you catch that up and delete those individuals. The net is that you need to consult with your service bureau and conduct an engagement-specific data assessment so to understand what services you're using and how that data might flow through their organization so that you can feel comfortable they're doing a good job applying the deletes. Next slide.
One question before we move on, Tom.
Sure.
This is directed to you, and please use the Q&A box, not the chat, for questions, if you would please. And if you want to direct them to a specific panelist, please indicate that as well. So Tom, this is directed to you. Is the 45 days for a service provider to delete beginning when the request is received from the business, given that the business may already have taken some time to send the request to the service provider? Does this change anything?
David, correct me if I'm wrong. My belief is yes, the clock starts when you receive the request, subject to that smaller allowance perhaps that you can verify that it's legitimate. David, is that legit?
Yeah, that's correct. Unfortunately, even the verification time is included in the 45-day period. There is there's a potential to have an additional 45 days if the request is especially difficult to deal with, but that has its own administrative requirements that goes with it.
Yep, I agree.
At the Vermont Country Store, we elected to transmit data to our service providers daily. And the intent was to ensure that we were never bumping up into a deadline. So if it takes us, if we're spending a week confirming that the person is who they say they are, and then we're transmitting the data, we simply wanted to ensure that we were never going to be in violation of a time limitation. And to a degree, if you're transmitting data, if I'm transmitting sales data to a service provider daily, why wouldn't I transmit flags that say, here's what the customer has requested me to do? And there aren't that many combinations of things that they can request under CCPA, and many of them we already do. So if you're asking me to stop mailing you catalogs, I have a mechanism for that, or had a mechanism for that before CCPA and was actively using it. It really is just the new things.
I agree with that. It speaks to the cadence of what your service provider is doing for you. So if you're doing daily updates, then certainly daily frequency of applying these, sending these CCPA requests is appropriate. If you do send them more frequently, daily, as that example, if your service bureau is not providing services at that particular cadence, then I would suggest that you also include the date of the request there, so that to the extent that the service bureau might be batching some of them reasonably within the context of what's allowed under the CCPA, that you're sharing the date that that it came in, which in the case of daily might be that very day. But just, you know, it's good to know the date.
And there's a question as to whether we will be sharing a copy of the slides and a recording of the presentation, and the answer to that is yes. All right. Did you say next slide?
Yes.
Yeah, Tom.
Yep. So let's talk about where are we not going to delete it? Where are we going to retain it, right? So there's an allowance, you know, thankfully from all of our perspectives, that you're allowed to maintain data on your archive or backup system until it's next accessed or restored. That's important, right? So cross country, we're doing full mirrored backups of our entire environment many times per day. We're getting in for individual job. We're getting in tons of mail file of rented lists, house file segment suppression lists. We have interim files as a project is going through its process from beginning to end. And then upon completion, you know, files are completed mail files, list rental orders shipped, on and on and on. So it's fortunate that there is that reasonable allowance that data that exists on backup systems does not need to be acted on if it's going to age out to its natural deletion over time. It's certainly good in our case. On the next slide, we'll get to in a minute. It's good that you're also able to, of course, make security representations that you are going to be ensuring the protection of that backup, or all that data for that matter, but backup data in this context until such time as deleted. That's really important, of course, as well. The other time it's reasonable to retain data is if it's needed for compliance, whether it's, in our case, us just keeping track of them so we can recreate the audit trail, tell you that, yes, we received and we applied. And secondly, and this was, Ben, one of your questions as well, for ongoing application, right? It's got to be reasonable to maintain a delete request if we have to continue to delete them from all subsequent mailings. There are a few other allowances David mentioned that I'm not going to go into because it's more subjective, that you have to build your own case on a marketer by marketer or business by business basis as to what cases you have for making the determination that you're not going to have yourself or your service bureau potentially delete certain data. We can go.
Tom, we have a follow-up, and I believe the question is with respect to the 45-day timeline. What is the merchant's obligation if the customer does not respond to a request for verification?
David, that's better suited for you.
Yeah, I can speak to that one. If you make a good faith effort to verify and are unable to do so, your obligation is to inform the requester that you are denying the request based on the inability to verify the request.
I think the key thing here is you have to log what you did. The customer gives you a request, you put out, you know, you send them a letter saying, I need to verify your information. If they don't get back to you, you still have a record of the fact that you did this. It isn't simply a pile of mail in, a pile of mail out. So
documentation.
Documentation.
And Tom, this one is to you. Can service providers apply a fee to processing CCPA requests? For example, if you need the name address deleted from a database, can the service providers charge a fee to the business for each request?
I believe they can, sure. In our case, our position is that we're not charging a fee. You know, I will throw a caveat out there sometimes that, you know, within reason, so to speak, if somebody is doing one mailing with us a year and we're charging them $1,000 for the year, yet they want us to receive daily CCPA requests and be a part of their compliance effort, you know, that's a different animal. But generally speaking, we try to structure it so that it floats well within the existing confines of our relationship without charge.
And if I could just jump in on that real quick, just to be clear, you cannot pass that on to your end consumer. That would be a big no-no.
Yep.
Yep. Great point.
And if none of our service providers charge a fee. They did charge us. We did pay setup fees to automate the transactions, and And that was an upfront expense to create that digital pipeline back and forth. But beyond that, there hasn't been anything beyond that.
Okay, great. Thank you, Jim. If we pulled any California customers from being fed into the co-ops, would we still have to have an opt-out button on our website, and would we still have to comply?
If you are meeting the threshold for either of the thresholds for being under the jurisdiction of the CCPA, you would, even in that situation, you would still have an obligation to provide that do not sell button, even if in every case you had already implemented a do not sell on their behalf.
Okay, thank you. And I think you said next slide.
Yep, and it's the last one. All right, so just worth noting, there's nothing in the CCPA regulation that's requiring you to have a third-party certification or requiring that your service providers have it as well. But and those examples being an ISO 27001, a SOC, being HIPAA compliant, GDPR compliance, there's others. But I will say that to the extent that you can have such a certification or have vendors have such certification, it does provide some reassurance that they understand how to protect data and how data flows through their organization. You know, we have these. If we hadn't had these, I can tell you it would have been a lot more difficult to get a handle on all this data flow when you have hundreds of clients and tens of thousands of data files coming in and interim work files and this and that for different services. So it's not a answer. If someone provides you with a third-party certification, do not take that to mean that they are automatically CCPA compliant. But I think that that's something that's additive to the process. If they can provide that, you can feel a little bit better about their answers to the CCPA compliance points. And that's all I have.
Okay, and I have a question from Al Basine. Al, I've unmuted you, and you should be able to ask that live.
Sure, just a quick question, and I think I may have answered it myself. But with respect to notice, David, you stated that notice has to be given at the time the information is collected or requested. Then essentially having an opt-in to the specific privacy policy, and then also having the privacy policy accessible on every page, for example, in the footer, would that be sufficient?
That should suffice. And I should say that in one of the few good pieces of information to come out of the regulations, the Attorney General is taking the position that a pop-up is not a requirement, as long as there is reasonable access from the point of entry to the website to the privacy policy. So in a sense, having that opt-in would be preferable as a prudential matter, but not necessarily required as a legal matter.
Great, thank you.
Great, thank you, Al. And back over to you, Tom.
That was my last slide, so I'm good.
Okay, sounds good. Right, we have a few more questions in here, and just to be clear around the availability of the presentation and recording, that'll be on request. If you'll send an email to pmiller, PMILLER @catalogmailers.org, we'd be happy to share the material with you. We are currently fielding do not sell requests and asking co-op partners to remove it from their database to avoid further sharing. Does ACMA know if the cooperative as a whole plans this approach as standard practice to ensure all member compliance?
I don't believe that's true. I don't believe that's the case. I think they're viewing it as if I get a request from a Vermont Country Store customer, I have to take action on that piece of data that's mine. Somebody else who contributed their piece of data on the same customer is under no obligation to honor the request the customer made to me specifically.
Okay, very good. Thank you, Jim.
Is that your understanding as well, David?
That's consistent with my understanding, and that although I'm less certain of this, I believe that the co-ops are consistently taking the position that with respect to this personal information, they are a business and not a service provider. and therefore they have an obligation to honor requests made of them, but not necessarily requests made of anyone else.
Okay, great. Jim, I'll turn it back over to you then.
I just wanted to recap our story, and at the Vermont Country Store, we began this journey really with Brandon Isaacson in March of 2019, and we didn't want to be trying to deal with this. Our bias for pushing it early. We're a highly seasonal business. We really needed to get this out of the way before we got to the September technical lockdown, and we wanted to be able to bring it live in December. So all of the footwork needed to get done in 2019 in order to have it up and running shortly after Christmas in 2019. I would say the way we picked it apart for those who are just embarking on this journey, we looked at the customer-facing side of it first, in large part because that bought us time. So it was ensuring that we had new terms and conditions that were aligned with the privacy policy. And we, unlike many, elected to establish a privacy policy for each state. And it was, at that point, California hadn't really figured out what they were going to do or how they were going to enforce it. We knew we wanted to carve out California, and then other states were making noise about doing something similar. So we really only have two. It's California and everyone else, but we have the option of having California and the son of California that may come up later as options. I would say that the internet side of it, getting the website tuned up, took more time than the work with co-ops. And broadly, there hasn't been a huge response. Most customers, and I think where the CCPA went off the rails is, when customers are getting barraged with catalogs, they want to be able to go to you and say, don't rent my name. I want to continue to do business with you, or I don't want to receive any more catalogs, and we have a process for that. It was really these requests for data that were new, where I want you to tell me what you have on me, and I want to decide what I want to do with it. The CCPA wasn't written, you can take it to a technical extreme, but I think consumers just want to know, what do you have on me, and am I comfortable with it? And if I am, I'm fine. And if I'm not, I want you to delete it. And we have we've established a fairly automated process to deal with it. The thing that we didn't automate was the tracking mechanism, and that is manual, but we're only getting about one of these a day, and a chunk of them are easy. It's do not rent, do not mail. Some of them are specific to emails. We have, and there are some wild little stories that pop up where you have an irate customer who's, this is last week, we had a customer who was irate because he wanted his information deleted. He didn't want to receive catalogs or emails anymore, and he kept getting emails. Well, he didn't remember, but he had a Hotmail account 3 years ago and then a Gmail account last year, and he signed up for emails under both, and he was forwarding the Hotmail to the Gmail. And in the end, we didn't match those two things together because the Hotmail was signed up before he started placing orders. So these things, in the end, he didn't get what he wanted for some time because we couldn't figure out how he was getting emails to begin with. These requests create more thorny problems than you expect, but broadly, these things have become more and more automated, and as time has gone on, it's easier. I'd say at this point, California, when I look at the variety of laws that they've passed, I'm probably expending a full-time equivalent just dealing with California legislation, and then throw in sales tax, and there's another FTE to deal with sales tax. These states that are getting their hooks into us are creating an administrative pain in the neck for everybody. And that was all I had.
Okay, Jim, thank you very much. Do have a couple of other questions. One is, does the delete request delete the record or just part of the record, and beyond the fact that I'm a past customer?
Delete request, I can take part of this, at least on the legal side. A delete request can be see how to put this. If to the extent you have information that you need to retain about the customer, as we've talked about before, for the purpose of the business relationship, you do not have to delete that information. To the extent that there is information that you do not need and that fits into that category, then you either can purge the information, or alternatively, if it's possible, technically, if you can disaggregate it so that the information is retained but is not in any way reasonably reassociated with the customer or their household, that's another acceptable form of deletion. And I hope that addresses the issue.
Okay, great. And related,
In our
go
case,
ahead.
we would delete, if we're going to delete, we're going to delete the header record, right? And then with it, that means that the transactional information goes too.
Okay, related to that, the merchant says we'll need to keep the information in order to suppress future marketing. Is that okay to tell them that?
Yeah, that's an issue that Tom addressed, and yes, it is. I mean, to the extent you're retaining information, you should be as forthright as you can reasonably be about the reason you're keeping it, and that is a legitimate reason.
Is there any recommendations on the verification process to protect against bad actors submitting partial consumer information in a right to know request? The
regulations suggest using one of two methods. One, if to the extent you have an account, a person has an account with your business, that's obviously the easiest way. You can just repeat. You just need to have them repeat the account information to in response to the request. Other than that, they recommend using 2 or more pieces of personally identifying information. There's a list of things you can't use. Social security number is on that type of thing. But if you ask for email address, phone number, and physical address, or some combination of information that satisfies you that the person asking has sufficient is the person about whom they're asking, then, and you, as Jim had said, and you document that process, then you should be in good shape.
And Jim, I think you wanted to get in on this or the previous question, but I think you were muted when you were talking.
Our experience is that almost none of the requests coming in are coming in over the phone. We haven't received a mailed piece yet. All of this is coming in online.
Okay.
That's what we're seeing with our clients as well, based on how they've been forwarding them in the beginning, at least. They were all almost coming in via the web.
We're also trying to get it. We want to explain to the consumer, what are you trying to get at? If you don't want to receive future catalogs, I can remove you from the list. If you don't want to receive future emails, I can do that too. The rest of it, the delete requests, I thought the way they structured the law wasn't particularly practical, where in the end, the consumer really wants to say, don't contact me any further with marketing messages, and I don't want you sharing my data because I don't want more marketing messages from others. And we're happy to do that. I think they really went too far with their conflicting messages, and the belief is, if you delete me, I will not appear in the ether anywhere, and I'm not going to get have companies following me around the internet or mailing me catalogs, and that's really not true.
Well, I think they modeled a lot on GDPR as well, right? They saw the GDPR regulations, and then they threw a lot of that in.
And how should I securely share information with a customer, a right to know request? Can we communicate through our customer service platform?
Once you've completed the verification process, and there are some technical elements to that that are worth exploring before you, but yes, you should be able to communicate using, once you verify the consumer, using the customer service platform. But I do want to re-echo something that Tom said. When you're communicating with anyone else regarding these requests, and just in general, the big fear out there is private litigation, private class action litigation. At the moment, under the terms of the statute, that right is limited to a data breach type of scenario. So on the front end, notice is essential to show that you're making a good faith effort to comply. Internally, data security is the most essential element, because that is the one that if you slip up, you can find yourself on the wrong end of a legal complaint in a lawsuit.
Very good. And this, David, is for you or for all of you. Are you aware of such services as mine, which is at saymine.com, to help customers batch or automate the process of requesting deletion from companies holding data on them. Second part to that is, in your opinion, does O authorize Google and Microsoft 365, that platform that uses requests as verified already, or would you still take the time to perform your own verification?
I would, on the first point, I am aware the statute and regulations specifically allow for the batching of requests. There are additional hoops that the requester has to go through, and you can, in response to a group request, you can require individualized verification of the members of the group, and I would recommend that you do so. I haven't looked into the details of the services for verification. I'm a little wary of them. To repeat Jim again on the same point, I think internal documentation of what you've done to comply at this point when things remain uncertain is pretty vital to show that you're actively engaged in this process and haven't passed it on to a third party.
We haven't had tremendous difficulty verifying. Most people who are sending us a request are using the email address that they placed an order. And we assume if they use this email address when they place the order with us and they're following up from the same email address, that it's them. There are very few that are disconnected. And to the point earlier, we don't allow hubby to reach out and say, I don't want my wife receiving catalogs anymore. Each individual has to reach out from their own email address regarding the transaction in question or transactions in question.
Great. Are there other states that are close to passing privacy regulation?
At the moment, I would say that the pandemic has essentially created chaos in the state legislatures. And so efforts in states like Washington haven't gone anywhere at this point. The bad news is that California may be about to come back for a second bite at the apple through something called the California Privacy Rights Act, which is a ballot initiative that likely has enough signatures to appear on the November ballot in California. It would expand the definition of personal information, expand the private right of action, create an entire new administrative agency to oversee privacy matters in the state of California. So I'd say I'd say continue to keep your eyes focused squarely on California, both for CCPA purposes and for this follow-up legislation.
Okay, good point. I think we're through all of the questions. If we haven't answered your question or one comes up as you think about this material, feel free to email us and we will pass it on to our experts here and try to get you an answer. I'd like to again thank our sponsors, Randall, Navistone, and Midland Paper, for being able to make this available to the industry free of charge. I would ask you to please consider getting involved with us. If you're not an ACMA member already, we certainly need the help. And as I said before, it is a numbers game in Washington. And to the extent we have a wide variety of companies in all 50 states involved, we have contacts to all of our national legislators. And it's also a good idea to build a relationship with your state legislators. They tend to be national legislators a little later in their career. Any concluding remarks, gentlemen?
No, nothing for me. I think you all are asking the right questions. And I guess I would only say from my perspective that making a good faith effort at compliance in this time of uncertainty is the key thing, to be seen to be actively engaged with CCPA and not let it come and hit you and surprise you.
And I would echo that. I think when you think about the customer facing side of this, I think it's incredibly important to have a California specific or a privacy policy that addresses the CCPA issues and have it up on your site and have your site be compliant. Even if the back end, even if you're still working on it, address the front end side so you take the target off your back.
I think we're all feeling a little bit like we have a target on our back in a number of ways these days. Gentlemen, you guys have been terrific. This has been really a terrific sharing of information and experience. Really appreciate you taking the time to do this. Appreciate all the attendees. If you are interested in getting information or additional information or getting involved, please reach out and get in contact with us. Give us a couple of days to service your request for information. And thank you for coming. We'll hopefully see you at the ACMA forum each successive Wednesday in September, virtually, and I promise not to serve any buffet lines anytime soon. Thanks a lot, and this now ends our webinar.
Thank you very much.
Thanks, all. Appreciate it.
Thank you.